everyone, and thank you for joining us for another Copyright Essentials series webinar. Today, it's for writers. The plot thickens. My name is Alicia Morris. I work in the Public Information Education Office, and I'm the host of today's webinar. Before we start, I'd like to share just a few logistical announcements with you. During today's webinar, you will be able to submit questions using the Q&A button at the bottom of your screen. We will answer these questions after the presentation is complete. However, we may not be able to answer all of them. And since this session is being recorded, please note that if you choose to participate and your question is addressed, it will be included in the recording as part of this webinar. I would also like to encourage you to complete a survey after this webinar ends. It will pop up on your screen, will take just a few minutes for you to complete, and will be a tremendous help to us when planning our future events. And now I would like to welcome Miriam Lord, Associate Register of Copyrights and Director of Public Information Education Office. Hello, Miriam.
Thank you so much, Alicia. Well, good afternoon or good morning to you all, and thank you to everyone for joining us from all over the United States to learn about how writers fit into the copyright system and about free resources the U.S. Copyright Office provides to help. As Alicia mentioned, I'm Miriam Lord. I'm Associate Register of Copyrights, the Director of the Office of Public Information Education here, or PI. I have a background of helping people understand all areas of intellectual property law, and here I oversee a team who provides authoritative information about the copyright system and provides assistance to the public. And you'll hear from some of the knowledgeable folks on that team here today. They'll get into the details, they'll provide you with the resources, they'll address some key frequently asked questions for writers and those business and legal advisors who support them. This series, Copyright Essentials, aims to serve you where you are on your journey. Literary works inform and inspire us all, and it takes work to create them. As you'll hear today, the copyright system provides the framework to allow creativity to flourish, benefiting us all. The U.S. Copyright Office's priorities include making the copyright system as understandable and accessible to as many people as possible. This includes at all knowledge levels, all industries, and in all states. It's my great pleasure now to introduce you to the leaders of today's session, attorney advisors Jessica Chinnadurai and Laura Kaiser. These two have shaped this session and the Copyright Essentials series as a whole, from myth-busting to explaining copyright as it applies to photographers, visual artists, to musicians, and now to writers. So thank you so much for your attention today during the duration of the webinar. And now over to you, Jessica and Laura. Take it away.
Thank you, Miriam, and hello, everyone. We're so excited to have you here, and thank you for joining us. We really are thrilled that so many of you are interested in learning about copyright. And just in case you missed some of the opening remarks, I wanted to repeat a few logistics. So first, this event is being recorded and captions are enabled. And then throughout today's webinar, we will provide a few resources and highlight them, and then we'll put associated links in the chat throughout the program. Additionally, as Alicia mentioned, there will be a survey after the webinar that we would very much appreciate you completing because we do develop programs like this with your feedback in mind. As Miriam mentioned, today your presenters are myself, Jessica Chinnadurai, and my colleague, Laura Kaiser. We are both attorney advisors in the Office of Public Information and Education at the Copyright Office. We frequently participate in outreach projects like this webinar, and we enjoy demystifying copyright and helping the broader public understand what it is. For a brief overview of today's webinar, we first have planned a high-level overview of the Copyright Office. Then we'll talk about a few of the basics of copyright law before getting into some common questions that we hear from writers. So we'll provide some considerations for writers and then important points to remember. And then we'll dive into copyright registration and a few application options that are geared towards writers specifically. Today, you will also have the pleasure from hearing directly from our staff in the office, the Copyright Office's Public Information Office. We're always reminding audiences that you can contact staff here at the Copyright Office with your questions. And you might wonder, are they real people? They absolutely are, and we want you to be able to meet them and know that you can contact them at any time. Lastly, we'll be ending by answering a few questions from the audience, so please do use the Q&A function to submit those. And let's dive into today's presentation with some history. So the United States Copyright Office was founded in 1870 and we are a government agency that's part of the Library of Congress, which means we're part of the legislative branch of government. And when we talk about copyright, the Copyright Office administering the Copyright Act, that is a broad statement that entails a number of different roles. And so we just kind of wanted to break down the various ways the Copyright Office carries out its mission. The office has several important duties that overall help fulfill copyright's constitutional purpose. And our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. Our small but mighty team of about 450 employees has many responsibilities. First, we make and maintain records related to copyright ownership. That does include registration records as well as recorded documents about transfers of ownership. The office also administers statutory licenses and helps manage and distribute royalties as required by law. And then Congress has also delegated authority to the office to develop regulations. These concern many areas of copyright law, like rules governing the submissions to the office, different types of applications, fees paid for the office's services, and FOIA requests, and more. Essentially, these regulations provide the public with a well-functioning copyright system. And at this point, I'm going to hand it over to my colleague Laura to walk us through some copyright basics.
Thanks, Jessica. So copyright law is found in Title 17 of the U.S. Code, also known as the Copyright Act. The law states that copyright protects original works of authorship fixed in a tangible medium of expression. So what this means is that we first must have a work of authorship, and that work must be fixed and original in order to be protected by copyright. We're going to go over the works of authorship categories in just a moment, but let me take just a second here to explain what fixed and what original mean. Fixed basically means that the expression needs to be written down, recorded, or otherwise captured in a copy, and it needs to be sufficiently permanent or stable enough that it can be perceived, reproduced, or communicated for more than a transitory duration. The important point to remember here is that the moment a work is fixed is the point that copyright protection actually begins. Originality in copyright involves two components. The first is independent creation, and the second is sufficient creativity. Independent creation means that the work needs to be independently created by the author. So that just means it needs to originate from the author, and it can't be copied from another work. So in theory, you could have two works that are the same or similar, and they can each have copyright protection as long as those similarities are just by chance and not the result of copying. Sufficient creativity requires that the work contain at least a small amount of creative expression, and that small amount needs to be more than trivial. As we'll learn more later, words and short phrases, book titles, and facts are not protected by copyright. The term work of authorship means the subject matter protected by copyright. Those broad categories include what you see here on this slide: literary works, musical works, including any lyrics, dramatic works, pantomimes and choreography, pictorial, graphic, and sculptural works. That includes fine and graphic art. Some examples are photographs, sculptures, and paintings. Motion pictures and other audiovisual works like video games, music, and movies, and TV shows. Sound recordings, and some good examples of that are audiobooks, podcasts, and music. And finally, architectural works, including houses, office buildings, and museums. Now, our focus today is writers, so the work of authorship category that's most applicable are literary works. And literary works include a wide range of material. So it's not just books, it's also poetry, articles, dissertations, brochures, magazines, blog entries, social media posts, and even source code for computer programs. And while dramatic works are not the focus of our presentation today, we do want to highlight that we might have writers of dramatic works in our audience. Dramatic works include plays, musicals, and operas, potentially even screenplays for a film, and copyright protected writing takes many different forms, as you can imagine. So let's take a closer look about how we define a literary work specifically. In copyright law, we have the definition on the left that literary works are those expressed in numbers or other verbal or numerical symbols. Put another way, we define a literary work as a non-dramatic work that explains or narrates a particular subject, theme, or idea through narrative, descriptive, or explanatory text rather than dialogue or dramatic action. So this is what distinguishes literary works from dramatic works. Generally, literary works are intended to be read rather than performed. And as I mentioned just a moment ago, there are many forms that literary works can take. So from your favorite novel to the newspapers you might read either in print or online, to textbooks you might be reading in school if you're a student, literary works truly are everywhere. So with that, let's get into some common questions you might have asked yourselves as writers. Before we start with our questions, we do have one important note. The office knows and understands that there are many questions and topics to address here. There's too many for our 1-hour webinar today. So what we've done is compile the most frequently asked questions, and the objective here is to help explain some considerations to keep in mind and points to remember when it comes to writers and their work and copyright. So our first common question is, I found my grandmother's old diary entries in a box in her attic. Who owns those diary entries? So the copyright concept that's important to consider here is the nature of copyright ownership and what that means. Owning the copyright in a written work is different from owning the physical object itself. A copyright owner is typically going to be the author of the work. That's the person who's actually putting pen to paper or who's typing the words on their computer. And as the author and the owner of copyright, you do have a set of legal rights that allows you to use or to give someone else permission to use the work in a few different ways. For authors of literary works, these rights include the right to copy the work, to create derivative works, such as turning the diary entries into a full novel, distributing copies to the public, for example, selling copies of the diary at a local market, publicly displaying the work. A good example of this is putting the diary on display at a museum, and the right to publicly perform the work, like reading the diary entries out loud at a public park. No one can use the work in one of those ways without your permission, without the copyright owner's permission. In the case of the diary entries in the attic, because the grandmother wrote them, she is the original copyright author and owner of the entries. The question of who owns the physical diary itself is actually a separate issue. So the next natural question might be, if the physical diary was gifted to a family member, or maybe it was loaned or sold, what does that mean for the copyright? Transferring ownership of the physical object does not mean that the copyright is gifted, loaned, or sold. So even if a family member has possession of the diary, that doesn't mean they necessarily have the right to copy it, distribute it, or make use of any of the other exclusive rights we just mentioned. The copyright and one or more of the exclusive rights can actually be transferred either verbally, in writing, through a will, or through state law when someone passes away without a will. And in that case, while the grandmother is the author, someone else might end up as the copyright owner. Also relevant here is how long copyright lasts in a work, because copyright does not last forever. For works that are created on or after January 1st, 1978, copyright lasts for the life of the author plus an additional 70 years. That general rule and the duration calculation changes depending on a number of factors, including if the work was created prior to 1978, whether or not the work was published, and whether or not the work met the requirements for copyright protection before 1978. We have a circular dedicated to duration, and we'll put that link in the chat if you'd like to learn more. So in short, the question of who owns the grandmother's diary entries is actually a bit more complicated than what it might seem on the surface, but we hope that this gives you an idea of the copyright concepts to consider and remember. And I'll toss it back to Jessica for the next question.
All right, thanks, Laura. So the next question that we commonly hear from writers is related to having a unique story idea or a unique character. And the question is, are they protected by copyright? So the first consideration here is that copyright protects the expression of your idea, but not the idea itself. And as writers, what we mean by the expression of your idea is the words that you've chosen to portray your plot or characters and settings in your story. Words or images expressing your ideas might, for example, describe the physical attributes of a character, like their facial features, hairstyle, or body shape, or let's say the physical characteristics of the town or country where your story takes place. For any of our writers who are listening in who are also visual artists, another way to reframe this and consider characters is that copyright might protect the way they are visually depicted, for example, in a drawing or a sketch. But again, copyright does not protect the general idea for either. So remember that at the beginning of today's webinar, Laura broke down copyright principles and explained that copyright protects original works that are fixed. Originality is a key principle in copyright, and it's not the same as uniqueness. Instead, originality in copyright law has two parts. Some of this might seem repetitive, but it's really important to this concept. The first is called independent creation, and that means that you, as the author, have independently created the work. You didn't copy someone else's work. The second component is called sufficient creativity, and that just means that the work has to have creativity that's more than trivial, what we often refer to as a spark of creativity. Now, although the bar is low, it does exist, and that's why you won't find copyright protection in things like individual words, short phrases, titles, and slogans. Those are all the building blocks of your literary works, and so all writers need to be able to use them. Another point to remember is that copyright does not consider the amount of time or money you've spent writing something, how successful it is commercially, or what its intended meaning is. In that same vein, a work doesn't need to be innovative or presented in a particularly surprising way, but it does have to be more than mechanical, routine, or typical. And again, just to frame that in the writing context, what typical could mean is that copyright doesn't protect stock characters, settings, or events that are common to a particular subject matter or medium. For example, a car chase in a script for a thriller movie, a love triangle in a romance novel, or the use of spy gadgets in a short story about a spy are events that are common to that particular subject matter. And because they are commonplace, they lack originality under copyright law. Lastly, just worth noting is that titles and names are also not protected by copyright, including names of characters, but another area of intellectual property, trademark law specifically, might provide protection if your character's name meets the trademark requirements. And with that, back to Laura for our next question.
Thanks, Jessica. So our next question is, I've heard that I can use someone else's words in my blog post as long as I use quotation marks or give them credit. Is that true? So the first key consideration here is that using someone else's copyright protected expression without their permission could be copyright infringement. Remember that we talked about the exclusive rights of copyright owners, and that only the owner has the right to copy, distribute, create derivative works, publicly display, or publicly perform their work. So giving the copyright author or owner credit or using quotation marks around someone else's words doesn't necessarily mean that the copyright owner couldn't bring a claim for copyright infringement against you. Remember that plagiarism and copyright infringement are two different, though sometimes related concepts. Plagiarism is not a legal cause of action, but copyright infringement is. So passing off someone else's expression as your own could have non-legal consequences, such as societal disapproval or disciplinary action at an educational institution. And copyright infringement, that's making use of one of the exclusive rights when you're not the copyright owner and you do not have permission, could have legal consequences, such as paying damages to an injured party or potentially being ordered by a court to stop infringing activity. Now, these two concepts, they can overlap, they can occur simultaneously, but as writers, we think it's important for you to be aware of the differences. And on a related note, we often hear the question from writers of whether they can use song titles in their book title. And the short answer here is that while titles generally are not protected by copyright, they could be protected under trademark law. So it's important to keep in mind that copyright is just one of the many areas of law that could be relevant to these decisions. Back to you, Jessica, for the next question.
Thanks, Laura. So this is a very common question related to pen names. You might be an author, you might want to use a pen name on your book or your blog. Does that affect copyright is the question. First, let's consider what a pen name is. A pen name is called a pseudonym in copyright law. And what a pseudonym is a fictitious or completely made up name that an author uses and their readers know them by. So importantly, we stress it's a fictitious name that's not the same as a nickname or an abbreviated legal name. So for example, if I was a writer and I went by J. Chinnadurai or my initials JMC, those are not my pseudonyms because they're not made up. So now that you know what a pseudonym is, it's helpful to know what using one on your work means. So when an author places a pseudonym on their work instead of using their real name, the work may be considered a pseudonymous work under copyright law. But this is true only when the author's real name does not appear anywhere on the work. So lots of authors might put their legal name next to the copyright notice, the C in the circle, on the title page of their book, for example. But doing so does mean that the work is not a pseudonymous work for purposes of copyright registration. To answer the initial question here, does using a pen name affect copyright? The short answer is yes. And some points to remember are that if your book or blog is a pseudonymous work, that might affect the duration of your copyright. That just means how long your copyright lasts. So Laura mentioned earlier that the general duration of copyright is the life of the author plus an additional 70 years. But for pseudonymous works, copyright expires 95 years from the year it was first published, or 120 years from the year of creation, whichever is shorter, or we mean whichever expires first. So you'll notice there's no mention of anyone's life because it's unknown who the author is, and then it can't be determined whose life we're talking about. That's also why if the legal name of the author is identified in the records of the Copyright Office, then copyright will revert to that general term, the life of the author plus an additional 70 years. Pseudonyms really in general are an important consideration when you register your work with the Copyright Office. And to learn more, we also have a circular on this topic. It's Circular 32, and we'll share a link to that in the chat. Before we get to registration, we do have a couple more questions to get through. So back to Laura for our next one.
Thanks, Jessica. So another question to consider is, my friend and I wrote a children's book together. Let's say he drew the illustrations and I wrote the text. Who owns the copyright in that book? So generally speaking, each author, the author of the text and the author of the illustrations, each will own the copyright in their individual contribution to the work. However, two or more authors may create a joint work when they intend to merge their contributions into a single work. So in this case, the children's book. And that means when the writer and the illustrator made their contributions, they had planned to combine them so that the writing and the illustrations were inseparable or interdependent parts of the whole book. Remember that for joint works, the intent of the authors is a focal point. So the creator's plan should be in the form of an agreement or some other indication that the creators were clear about their intentions of merging their contributions. The amount of copyrightable authorship, the quantity of it that's contributed, is actually not a factor for determining whether you have a joint work. Also, the individual contributions must be merged into inseparable or interdependent parts of the whole work, the children's book. Inseparable here means that the contributions can't be separated. It's really not clear who created what. So this often will apply to works that contain a single form of authorship. For example, think about a novel. If all of the text was jointly written, it's unlikely that someone would be able to identify which sentence was written by which author when reading the book. Interdependent means that the joint author's contributions depend on each other to create a full, complete, and wholly original work. This will often apply to works that contain multiple forms of authorship. And a children's book is actually a great example because the story and the text is a literary work on its own, and the illustrations separately are pictorial works, which is another category of authorship. So we can separate the illustrations from the text of the story, but then we wouldn't have the complete children's book, so those contributions would be considered interdependent. A second important point to remember for joint works and why it's consequential is that each owner has the right to exercise any of the applicable exclusive rights, and each owner individually can transfer one or more of those rights to others or authorize others to use the work in one of those ways. So, for example, one joint owner could give someone else permission to sell the book online, and they can do that without asking permission from their co-owner. However, if a joint owner does do this, they do need to share any royalties or profits equally with all of the other copyright owners, unless, of course, there's an agreement that says otherwise. If you're interested in learning more, the Copyright Office has a learning engine video series on YouTube, and one of those videos is called Copyright in Collaboration and discusses this concept of joint works in more detail, and we've dropped the link to that video in the chat. And with that, I'll pass this over to Jessica for our final industry question.
Great. So although this is our final industry question for this portion of the webinar, don't forget that you can add your questions to the Q&A. And if we have time, we'll get to those, or we'll be able to answer them another way. Our final industry question, though, today is about writing an article that will be published in something like an academic journal or other sort of periodical. Think about magazines or newspapers. Many writers might ask, well, if my article is included in that sort of publication, does that mean that the journal or the magazine company now owns the copyright in my article? First, let's consider what type of work an academic journal is. Like magazines, newspapers, and some textbooks and cookbooks, academic journals are often examples of what we call collective works. In copyright, a collective work is where several contributions that are independent, meaning they're standalone works, are assembled into that one work or that one collection. Other examples might include a book of poetry or a textbook, for example, where each chapter is written by a different person, or perhaps even a cookbook with multiple recipes written by different people, stories and photographs by different people, or artwork of the food. Each independent work there is what we call a contribution to a collective work. And for those who don't know, a contribution to a collective work is one type of work that can be commissioned as a work made for hire. So just some more details on works made for hire. In order for your article or contribution to qualify as a work made for hire, remember that copyright law outlines some specific requirements that must be met. For commissioned works, there must be a signed written agreement between the parties stating that the article or the work is being commissioned as a work made for hire. Now, a work made for hire can also be created by an employee in the scope of their employment. That means it's part of their job descriptions. But in this question, we're kind of assuming that you're not an employee of the academic journal and you've just been commissioned. So returning to that question of whether or not the journal owns the copyright in your article, the answer is not unless there's a work made for hire agreement or another written contract that says you, as the author and copyright owner, are transferring copyright ownership. We've said this a few times today because it's really an important point to remember, but the initial copyright owner of a work is its creator or the author. And so if there's no agreement or contract stating otherwise, then as the author of the article, you remain the copyright owner as well. And with that, I think we're going to move forward to the next portion of our presentation, which is registration.
Okay, great. So registration is such an important part of the Copyright Office's work. So we are going to take a few minutes to give you some of the basics for registration. Since copyright protection is automatic and begins the moment a work is fixed, registration with the Copyright Office is voluntary. However, there are many important benefits when you register your work with our office. We are the sole administrator of the copyright registration system in the United States. So one benefit is that registration creates a public record that includes key facts about your work. So this includes the name of the author and the owner of the work, the title, the year the work was created, the year it was published, and the date and nation of first publication. Along those same lines, the registration record may also provide the name and contact information for the person or perhaps the organization who can field requests from those who are seeking permission to use the work. Importantly, registration is also a requirement if you find yourself in a copyright dispute and you'd like to access federal court or the Copyright Claims Board. For those who don't know, the Copyright Claims Board is a 3-member tribunal here in the Copyright Office that resolves copyright disputes where up to $30,000 in damages is at issue. So if a work is infringed, it needs to be registered with the Copyright Office, or the office needs to have refused registration in order for you to file a copyright infringement lawsuit in federal court. If you file a claim with the Copyright Claims Board, if you choose that route, you do need to have a registration from our office for the work that's at issue, or at least have submitted an application to register the work. So that can happen either before you file the claim or simultaneously. So with that, let's go over some of the logistics. Registration with the office is a relatively easy process. There are 3 basic requirements. They are a completed application, the filing fee, and a deposit for each work that you'd like to register. An application is a form that gathers all of the details about the copyright owner and the work, like the name and address of the owner, the year it was created, and the title of the work. We're going to go over fees a bit more in just a second, but generally the cost is going to vary depending on how many works you're registering and what kind of works they are. And finally, the office examines a deposit copy. The deposit copy is a physical or digital copy of your work. For literary works specifically that are published both electronically and in hard copy, you will need to submit complete copies in a hard copy format. If the work was only published electronically, you are able to submit a digital file copy of the work as long as it's complete and you submit it using an acceptable file format. So with these benefits and the requirements in mind, let's go over timing and cost. On average, registration applications submitted online are processed in about 6 weeks when no communication between our registration team and the applicant was needed. That's what no correspondence means on the slide here. When the office does need to communicate with an applicant, the average time to process increases slightly to just under 3 months. And in terms of the cost, that's going to depend, as I said, on the number and the types of works that you're trying to register. The general rule is that you submit one work with one application, and one inexpensive option is called the single application that costs $45. There's a number of requirements for this application, including that only one work can be registered. It needs to have been created by a single author, so no joint works and no works made for hire, and the author and the owner need to be the same individual. The standard application, on the other hand, has fewer restrictions. It costs $65 if filed online. It still can only be used for a single work, but works made for hire, joint works, collective works, those can all be registered using the standard application. In fact, for most works, using the standard application will be the most appropriate. And additionally, the office has created a number of group registration options that allow you to submit more than one work on one application, making the process more efficient, more cost-effective. Most of the group options are required to be submitted online, and those applications range in cost from $55 to $95. In general, you can learn more about the office's fees for registration and other services, and we'll put the link to that page in the chat. And with that, I'll give the mic to Jessica to take us through a couple of those group options.
Sure. So let's start with the group application, group registration for unpublished works. As Laura just discussed, though, the general rule for registration is to submit one application, filing fee, and deposit or copy of your work for each work that you want to register. But the office has established these group registration options, which can be used to register multiple works. Each group option has its own eligibility requirements that are important for you to pay attention to, and so you'll always want to check those out before you apply. But the group registration of unpublished works, or GRU for short, is a great way to register up to 10 unpublished literary works. That includes things like essays, short stories, novels, and more. The application has an $85 fee, and for each work that you intend to register, you have to submit a copy of it. And as the slide notes, all works must be in the same class, so they must all be literary works to be submitted on one GRU. Now, certain literary works cannot be submitted on the GRU. I talked about collective works earlier, like an academic journal or a textbook with chapters written by different people, or a book of poems. Those are examples of collective works that cannot be submitted on the GRU. But to reframe that, you can submit 10 individual poems, just not 10 books of poetry. And then lastly, you have to meet the GRU's eligibility requirements in order to apply. So there are several that we won't go over all of them today, but one important requirement is in the name of the application itself. It's that all works must be unpublished. A work is unpublished if copies have not been distributed to the public for further distribution or for public performance or public display. And if you're unsure about whether or not your work is unpublished, or if you want to learn more about the GRU, we do have a dedicated webpage that has additional resources, including a circular on the GRU, FAQs, and more. And so we'll share that link in the chat now. The other group option that we wanted to mention that's geared towards writers is the group registration for short online literary works. The shorthand there is the GRTX. So a short online literary work is a literary work that contains between 50 and 17,500 words, and it's first published as part of a website or online platform. That does include things like online newspapers, social media websites, and social networking platforms. So examples of short online literary works include columns, blog entries, and social media posts. Now, as with the GRU, all works must be published, but the difference with the GRTX is that the works must have been published online. So we won't go over all of the other eligibility requirements for this option either, but just know that those exist. So if you want to learn more about the GRTX, we have a dedicated web page for this option with additional resources, including a GRTX circular, FAQs, and more. And so we're sharing that link in the chat as well. All right, so we just spent quite a bit of time going through registration basics, including group options for writers. We understand that that can be a lot of information to digest, and so you might be asking yourself now or even in the future, what should I do if I don't know how to get started with my application, or I can't, seem to find answers to my copyright questions? Well, that's why we're introducing you today to the Public Information Office. They can provide a practical pathway to success, and they often do it all with a smile. In fact, we have a colleague from the Public Information Office, Jonathan Hawkins, who is joining us today to tell us more about the work that he and his colleagues do every day. So in just a minute, Jonathan will explain some of the services that we offer. But before he does so, just keep in mind that staff cannot provide legal advice. And areas of inquiry that might involve legal advice include assessing whether the use of a work is fair use, drafting or interpreting contract terms, evaluating publication status, weighing registration options with you, or providing an opinion on alleged copyright infringement. But that being said, we want you to know everything that the office can provide. So Jonathan, welcome. Thank you so much for joining us. Why don't we start with you just telling us a little bit about yourself?
Thank you and welcome. My name is Jonathan Hawkins. I'm one of the senior copyright specialists within the Public Information Office. I have been in and around the Copyright Office for about 20 years. For the last 11 years of my career, I served and continue to be of service to the public here in the Information Office. I would also like to mention that I too enjoy expressing myself through words. Nothing too serious, just some poetry here and there.
That's great. I too dabble in some poetry. So can you tell us a little bit more, Jonathan, about the Public Information Office and what you do every day?
Sure. So the Public Information Office, or PIO for short, is part of the Office of Public Information and Education and is central to the Copyright Office's mission and outreach goals. PIO is a team of about 20 subject matter experts responsible for responding to thousands of inquiries each year from members of the public in the United States and around the world. As a senior copyright specialist here in PIO, I greet and assist members of the public with questions about copyright law, the registration process, the benefits of registration, and I also provide walkthrough assistance. My colleagues and I provide these services by telephone, email, and in person when people visit the office in Washington, D.C. My favorite part of working at the Copyright Office is being able to interact and speak with creative and interesting people from all around the world. I am happy to assist as you navigate through your copyright adventure.
Thank you. So let's just take a closer look at some of the services that you mentioned, starting with a walkthrough. For those who might be unfamiliar, can you describe this service?
Sure. So PIO can provide walkthrough services between business hours over the phone to help you complete your online registration application during a 30-minute appointment. Our business hours are between 8:30 a.m. and 5 p.m. Eastern Time. So the last appointment can be scheduled for 4:30 p.m. During a walkthrough, a staff member will assist you with navigating an electronic registration application by explaining the application screens and the types of information required. The office can provide you with information to help you reach decisions about how to answer application questions, but we cannot provide you with legal advice. To request a phone walkthrough, you must request an appointment on our website, copyright.gov, using the contact button. When requesting a walkthrough, it is imperative to follow the directions and steps to confirm your scheduled appointment. Additionally, before your appointment, you must set up an account in the Electronic Copyright Office Registration System, also known as ECO, and you will need to have your ECO username and password ready at your appointment. Don't worry, we won't ask you for your username and password over the phone. If you haven't taken these steps, you will need to reschedule your appointment.
Great. Those are some good details for people to keep in mind. And you discussed how walkthroughs are often provided over the phone. So what about if someone wants to visit the Copyright Office on site in Washington, D.C. to get any type of assistance?
Well, sure. The office welcomes visitors to PIO in the Library of Congress's James Madison Building in Washington, D.C. Again, we are open Monday through Friday, 8:30 a.m. to 5 p.m. Eastern Time, and we are closed on weekends and federal holidays. You can request an appointment on our website, or you may also walk in during normal business hours. Please note, as with our phone walkthroughs, the last on-site walkthrough we can provide is at 4:30 p.m. There are several services we provide in person. For example, walkthroughs can be requested on site using our kiosk. If you do not schedule an on site walkthrough in advance, please note that this service will be provided on a first come, first served basis between previously scheduled appointments. That's also the general rule for all walk ins. When visiting the office, you can also request certified copies of registration certificates and deposits, which is another name for the copy of your work that must submit with a registration application. And lastly, Members of the public can submit requests for a search of the office's records. This is a service often used by people who are interested in investigating whether a work is under copyright protection, and if so, the facts of the copyright. For example, the copyright owner's name. For a fee, the office will search its public records and provide a report of its findings. We'll give you a rough estimate of how long it will take to process these kinds of requests. There's also a lot of information you can find online on our website, copyright.gov.
Well, that's great. Thank you, Jonathan. I know we're so helpful. We're so grateful for your help in describing some of the critical work that PIO does. So do you have any final thoughts to share, or what else should our audience know about the Public Information Office?
Well, all PIO staff speak English, and we also have a few specialists on the team who are able to assist you in Spanish over the phone or email. You may request assistance from a Spanish-speaking specialist by sending a request to the email address on the screen or by submitting a request using the form on copyright.gov after clicking on Contact. Additionally, the office has informational resources available in Spanish, including circulars, handouts, and FAQs. Lastly, remember that the Public Information Office is ready and eager to help you. So please get in touch with us today if you have questions about copyright or want to learn more about the services that we provide. I want to thank you for joining today's webinar, and we look forward to hearing from you. With that, I'll pass the mic back to Jessica and Laura.
Thank you so much, Jonathan, for letting us know all of the important services that PIO provides. We now have time to take a few questions from our audience today, and I'd like to invite Deputy Director of the Public Information Education Office, George Tironi, to help moderate our Q&A for today. So over to you, George.
Thank you so much. So much interesting information, and I know a lot of us have learned a lot. I've learned so much. I know a lot of us have as well. We have a lot of questions. We won't be able to get to all of them today, but Jonathan and his colleagues are standing by to answer questions in the future if you have them. So there are several versions of one question that a lot of people are asking, because writing is a process, and for some people it can go on for years. And so the question basically is, somebody writes something, then they edit it, and they revise it, then there's another version, then there's another version, and which version is protected under copyright and which version should be registered for copyright?
Yeah, I can take this one. We get this question quite a lot. As George mentioned, it's an important part of the writing process. And the answer generally, it depends on what kind of edits that you're making to each copy. So as we mentioned earlier, copyright is going to protect your original work of authorship as soon as it's written down. But if you register, let's say, a manuscript, and then you go back and make some edits, let's say some small grammatical mistakes were corrected, or you'd like to fix a few typos, generally those types of edits aren't going to have enough creative written expression that they would qualify for copyright protection on their own, so that new or second version fixing the grammatical mistakes wouldn't necessarily have additional material that could be protected by copyright. However, if you make substantial edits, let's say you write several new chapters, then it would be possible to register that second version as a derivative work. So just to define derivative work, that's a work that's based on one or more works that are pre-existing. So in this case, the second version of the manuscript would be based on that original manuscript. And it's where the work has been recast, transformed, or adapted in some way. So if a work has some editorial revisions or annotations that as a whole could be an original work of authorship, it's going to be considered a derivative work. And generally, our instructions to those who are applying to register, applicants should generally use the terms new text or revised text to describe that additional authorship. So I hope that gives you an indication of the considerations to keep in mind for multiple versions of your writing. Back to you, George.
That's great. Thank you. We've had a couple of questions about posting material online. So if you post materials online and then submit them for copyright registration, are they considered published or unpublished for copyright purposes? Jessica, would you like to take that one?
Sure, and I'm glad I get the chance to kind of dive into publication a little bit more. I know I was talking about it at surface level for the group registration options. Let's just take a step back. In general, publication is going to be the distribution of a work. And what we mean by distribution is that it could be sold, rented, lended, or leased to the public. But publication could also involve you as a writer offering your work to a group of persons, such as an intermediary or a publisher, for them to further distribute or publicly display or publicly perform the work. The important thing to remember here is that public performance and public display alone are not enough to make the work or to consider the work being published. So the office's existing policy on online publication just has a few more kind of details to keep in mind. The first one is really that the copyright owner has to authorize the work's availability online. In fact, if a work is posted without the copyright owner's permission, then it cannot be considered published. And then there's a second part there too, that if the work is expressly made available for download, then it's considered published because users, each time they download a copy, that's a distribution occurs. An example might be a writer putting up an article on their website and then posting it with the download now button. So all that to say, I know online publication has been confusing for a lot of people throughout the years. The Copyright Office has conducted a policy study on it. We've provided updates on the subject, and more information can be found on copyright.gov, especially in our policy section. But we also have other great resources that cover publication, including the compendium, and then our recently released registration toolkit, which kind of dives into publication a little bit more. Hopefully that is a good overview.
Great, thank you. And speaking of online, can somebody register their website as a literary work, Laura?
Yeah, the answer to that one is possibly. So while a website is not usually considered a copyrightable work itself, it's not listed in one of those work of authorship categories when we went over earlier in the presentation. You might be able to register a website or a specific web page if it satisfies the requirements for a compilation or collective work, which we discussed a bit earlier as well. So as Jessica mentioned, in copyright, a collective work is where you have several contributions that are each independent works themselves, and then they're assembled into a whole work. And then a compilation is a work that's formed by pre-existing material, and it's selected and arranged in a way that the whole work becomes an original work of authorship. So for a website, this might mean that the content on the website itself, maybe it's coordinated and arranged in a creative way. There might also be sufficient creativity in the way that the web pages are actually connected or linked with one another. Alternatively, you can also consider the website content. That might include literary works. Any individual works that appear on the website, we do say that those should be applied for registration according to their predominant copyrightable content. So, for example, if you have a blog post and it contains mainly text, that could, for example, be registered as a literary work on its own. We actually, due to the commonality of this question and the fact that, this is something that comes up often for people, we have a circular that's actually dedicated to copyright registration of websites and website content. It's Circular 66, and we'll drop a link to that in the chat if you'd like a deeper dive on that topic. Back to you, George, for the next question.
Thank you. We've gotten quite a few questions about using AI to enhance or work with your product, either to create a translation or illustrations or additional text. Does the office have any guidance on using AI generated works?
So I can take that one. The decision to use AI in the creative process, at least, is a personal choice that every creator can make. In terms of where copyright comes into play, that's going to be with registration. And if you want to register, let's say, a translation created by AI, the way that copyright law would affect that is that copyright protects only works of human authorship. So if it was entirely translated by generative AI, for example, then that's not going to qualify for copyright protection. If you ask the generative AI to create your entire French translation and it does, then again, that cannot be registered. But let's say that you write some of the translation and then you ask the generative AI to write some parts too. Going to what George was saying about the office's policy, we do have guidance issued in 2023 that requires that when you apply for registration, you disclose to the office what was created by the technology or the AI, and then what was created by the human. And then with registration, in terms of what would happen if it's approved, it would extend only then to the human authored parts.
Thank you. Here's a good question for you, Laura. Here, someone asks, I was under the impression that you could quote under 40 words with credit to the original author, and that was acceptable under copyright law.
Yeah, this is a great question. This goes back to what I was saying about plagiarism and copyright and distinguishing those concepts from each other. It does not matter the amount of words. There's no set amount of words in the law or quantity of material that is, quote, safe to use or that inoculates you somehow from copyright infringement. It's whatever, if you're copying the creative expression of somebody else, that's generally going to be considered infringement unless you have permission or there's some agreement that you're able to do so. And then also keep in mind too, we have this concept called fair use, which sometimes comes into play with this, where people say, oh, if I use less than this many seconds of a video clip, for example, it's fair use, it's fine for me to do this, it's not infringement. So keep in mind that fair use is something that can only be decided by a court. It's a defense to copyright infringement that's raised in court or before the Copyright Claims Board, of course. And it's determined by the adjudicator, by the judge, or by the copyright claims officer who's in charge of that case. So they have to weigh 4 different factors that are in the law. It's very fact specific, very fact dependent analysis. So just declaring it's fair use because you've used a certain amount of words, that's actually not going to fly. The court and the adjudicator has to really consider all of the facts in that specific situation. So I hope that gives you a little bit more information on what to consider when you're using someone else's expression. Back to you, George.
Thank you. And as I mentioned, we had a lot of great questions, and feel free to contact us later. One more question for you, Jessica. Can an audiobook be copyrighted?
Sure. So Laura kind of started off the presentation talking about types of works that are protected by copyright. And one of those categories is, of course, literary works, which we covered today. But there is another category that's called sound recordings. People often think of sound recordings as like the recorded performance of a song, but it could also include things like audiobooks and podcasts and recorded lectures and speeches. So absolutely, an audiobook can be protected or protectable by copyright. So I think that was our last question. Thank you so much, George, for kind of guiding us through those. And like he mentioned, if you have any follow-up questions, you can always reach out to the Public Information Office, and we'll provide, those details are provided, I believe, on our website as well. So in terms of kind of closing out today's session, before we end, we just wanted to talk about a few of the resources available to you to help you learn more about copyright. We've talked today about circulars, our Learning Engine videos, and then we also have the Copyright Public Records System, and then, of course, our Public Information Office staff. There is a special resource that we kind of wanted to pay particular attention to today before you leave. It's called the Engage Your Creativity web pages. It's pictured here on the laptop in the screen. So we have dedicated web pages for a variety of specific professions. This one shown here is dedicated to writers. It's called What Writers Should Know About Copyright, and it does provide some of the information Laura and I talked about today, as well as additional resources. So I think we're going to share a link to that in the chat as well. Lastly, for updates from the office, you can also subscribe to our digital newsletter. It's called Newsnet, along with our blog, other events, and legislative developments at the link here on the bottom of the screen. And then finally, we do encourage you to follow us on social media. We're active on X and LinkedIn. And with that, thank you again so much for being here today. Just another reminder that a survey will be sent out to attendees, and we absolutely welcome your feedback and appreciate that feedback as well. So thank you all for attending today's webinar, and hope you have a great rest of your day.